that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Githu Muigai, Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, and Mr. Charles Mutinda. The Attorney General submitted that accountable governance was a core part of the Constitution, which established removal from office through impeachment as one of the tools of governance amongst the many avenues of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Sonko, where the Apex Court stated that its purpose was to ensure integrity in leadership and prevent abuse of public office. It was the Attorney General's submission that the removal proceedings for a deputy president were textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders, that both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least 2/3 of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachagua were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachagua was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed among different organs, each exercising distinct functions under the Constitution, and that courts were required to respect the institutional mandate of a parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus IABC, our court and another, as well as it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties and amicus. On a comparative jurisprudence, the Attorney General submitted that both the United States and the Philippines recognize the political nature of impeachment proceedings, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Duterte decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149(1) was neither an election in the traditional sense nor an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the 9th respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment of H.E. Gachagua. He was aware that the special motion was a time-bound exercise pursuant to the Standing Orders 64.2 and 65, which required that it be disposed of within 7 days of the notice being given, failure to which it would be deemed as withdrawn. Honorable Mutuse averred that while Articles 145 and 150 of the Constitution and Standing Orders did not expressly require public participation in a special motion, Article 118(1)(b) of the Constitution imposed on the Speaker of Parliament the obligation to facilitate public participation in legislative and other business of Parliament and its committees. He deposed that it was in that spirit that the National Assembly, with a view to facilitate public participation, invited members of the public to submit their views, and public hearings were thereby conducted across all the 290 constituencies on 4th October 2024. A notice dated 4th October 2024 by the Clerk of the National Assembly extended the period of public participation to 5th October 2024. Honorable Mutuse confirmed that on 8th October 2024, Honorable Millie Odhiambo MP tabled the public participation report before the National Assembly. Honorable Mutuse further deposed that on the 3rd of October 2024, the High Court sitting in Kerugoya issued orders directing the National Assembly to organize, facilitate, and conduct further public participation at the constituency level, and that the National Assembly complied with those orders by extending the exercise to the 5th of October 2024. Honorable Mutuse stated that following the tabling of the public participation report, the members of the National Assembly debated the special motion and that H.E. Gachagua appeared in person for the hearing. After debating and hearing both parties, the members of the National Assembly met the threshold set under Article 145(2) by passing and approving all 11 grounds of the special motion. Honorable Mutuse affirmed that the entire impeachment process, from the tabling of the special motion dated 26 September 2024 at the National Assembly to the Senate's resolution, had fully complied with all legal procedure provided in the Constitution and relevant laws. Honorable Mutuse emphasized that this court had a judicial and not a political mandate, and that its function was to certify whether all procedural provisions of law had complied with constitutional principles, which was a judicial function. He averred that the issues raised by the petitions raised a political question, a principle of law that referred to cases that courts could not resolve because they involved questions about the judgment of actors in the executive or legislative branches and not the authority of those actors. Honorable Mutuse also cited the position taken by courts in Paraguay, India, Lithuania, and the Philippines to demonstrate that jurisdiction practicing a presidential system of government had been appreciative of the political question doctrine in impeachment matters. He tabulated comparative examples of impeachment proceedings of USA presidents to show that in those jurisdictions, the fate of impeachment was left to political devices as opposed to judicial determination. Honorable Mutuse further deposed that under Article 94(2) of the Constitution, the National Assembly and Senate manifested the diversity of the nation and represented the will of their people and exercised their sovereignty. In conclusion, he urged the court to appreciate the prudential standing principle of self-restraint as a jurisdictional limitation on its power and prayed that the petitions be dismissed. Honorable Mutuse filed written submissions. Those were dated the 15th of February 2026 and were supplemented on 5th of May 2026. They were anchored on two issues: whether H.E. Gachagua was validly impeached, and secondly, whether the impeachment process was procedural. He submitted that H.E. Gachagua was impeached on grounds on various grounds under the Constitution, violation of national laws, and gross misconduct arising from his conduct. It was Honorable Mutuse's submission that the question for the court was not the political wisdom of the impeachment, but whether the grounds for removal had met the constitutional threshold under Article 145(1).